Hello there. Welcome to video 140 from Sumit Academy. I do hope that you have subscribed to my channel. Do subscribe now so that you do not miss out on my previous or future videos. And do remember to like and share this video too. And if you want to drop in a line, I shall always be available at sumitacademy20@gmail.com. To make your task a little easier, here is a complete list of all the 140 videos available on my YouTube channel. The list is divided into the playlists under which they are available. Do have a look. In this video, we shall talk about the concept of federalism in India. Federalism is a method of segregating powers so that the central and local governments are each within their domain. Before we go further, let us understand the difference between unitary and federal systems of government. Unitary system is a system of political organization in which most or all of the governing power resides in a centralized government. A unitary constitution is one in which the power to make law is concentrated in a single tier, a single level of government. The most famous unitary system is the United Kingdom, where the Westminster Parliament and the government it forms have complete authority as regards legislative and executive powers respectively. Sometimes it is difficult to discern whether a constitution's character is unitary or federal. If a country vests all law-making powers in a central authority and no such powers in its constituent parts, then it is clearly unitary. But a more subtle scenario arises when both the union and states are competent to enact laws. In such situations, we ought to pause before easily concluding that the country's constitution is federal. The question to ask is whether or not states enjoy independent constitutional status. Can, for example, the central authority take away the lawmaking powers of the states without their consent? If so, the country would still, in theory, operate under a unitary constitution, even though its daily practice may resemble a federal system. British India, under the Crown, embraced a largely unitary government with a centralized administration. The seeds of change came with the Government of India Act 1935, though the formulation of a federal system arose under atypical circumstances. Now, I do hope that you have seen my earlier video on the Government of India Act 1935. Ordinarily, federal systems emerge through an agreement between autonomous regions which opt to come together. In the Indian context, however, no purely autonomous regions existed. The 1935 Act at once created and combined such regions and provided an attractive framework for the Constituent Assembly. By the time the Indian Constitution came into being, it was decidedly federal. But because the Constitution tilts heavily in favor of the Union, many portray India as an imperfectly federal or a quasi-federal nation. Now, I feel that such reasoning is fallacious, that is, erroneous. The Indian Constitution may give the Union more powers than it gives to the states, but it does not establish the supremacy of the Union. Dr. Ambedkar rightly recognized the co-equal status of the Union and states under the Constitution. Since states are not dependent on the Union for their authority. India remains a federation because both the Union and the states are supreme in their own realms. The Indian Constitution is based on the principles of collaboration, reciprocity, and mutuality. It includes the distribution of powers among governmental bodies, each with limited and coordinate powers, along with the supremacy of the Constitution and the authority of the courts as the interpreters of the Constitution. The essential feature, which is the definition of federalism, is that there are two levels of government in the country at least. There can be two or more, but the entire power is not concentrated with one government alone. All levels of governance will govern the same citizens, but their jurisdiction will be different. This means that each level of government will have a specific power to form laws, legislate, and execute these laws. Both the governments will have clearly marked jurisdiction. The Constitution must guarantee this federal system of government, which means the powers and duties of both or all governments must be listed down in the constitution of that country, hence guaranteeing a federal system of governance. The federalism of a country must be prescribed by the constitution. But it is also important that just one level of government cannot make unilateral changes or amendments to the important and essential provisions of the Constitution. Such changes must be approved by all the levels of the government to be carried through. Now, there are two levels of government with separate jurisdictions and separate duties. Yet, there is still a possibility that a conflict may arise between the two. Well, in a federal state, it will fall upon the courts, or rather the judiciary, to resolve this conflict. The courts must have the power to interfere in such a situation and reach a resolution. While there is power sharing between the two levels of government, there should also be a system in place for revenue sharing. Both levels of government should have their own autonomous revenue streams. If one such government depends on the other for funds to carry out its function, it is not autonomous in its true nature. Federalism in India derives from the Constitution of India. It reconciles two essential principles of autonomy and integration. Unlike the United States Constitution, which is an example of dual federalism, India is an example of cooperative federalism. In dual federalism, the two governments are completely independent entities. Cooperative federalism is based on the concept of interdependence rather than independence. The two governments are dependent on each other. If states are financially dependent on the center too is dependent on the states for implementation and execution of union laws and policies. Hence, India is also seen as an example of executive federalism. The uniqueness of the Indian Constitution is also in the fact that although it is federal in character, it declares India to be a union of states. The West Bengal case of 1963 offers the first instance where this issue was discussed at length by the Supreme Court. The main issue involved in this case was the exercise of sovereign powers by the Indian states. The legislative competence of the Parliament to enact a law for compulsory acquisition by the Union of land and other properties vested in or owned by the state and the sovereign authority of states as distinct entities were also examined by the Honorable Court. The Supreme Court held that the Indian Constitution did not propound a principle of absolute federalism. Though authority was decentralized, this was mainly due to the arduous task of governing a large territory. The court outlined the characteristics which highlight the fact that the Indian Constitution is not a traditional federal constitution. Firstly, there is no separate constitution for each state as is required in a federal state. The constitution is the supreme document which governs all the states. Secondly, the constitution is liable to be altered by the Union Parliament alone, and the units of the country, that is, the states, have no power to alter it. Thirdly, the distribution of powers is to facilitate local governance by the states, and national policies are decided by the center. Lastly, as against a federal constitution which contains internal checks and balances, the Indian Constitution renders supreme power upon the courts to invalidate any action violative of the Constitution. The Supreme Court further held that both the legislative and executive powers of the states are subject to the respective supreme powers of the Union. Our Constitution makes a clear demarcation about legislative powers and jurisdictions. Now, how is it done? This is done through the three lists. First is the Union list. This includes subjects that carry national importance like defense, finance, railways, banking, etc. So on such subjects, only the central government is allowed to make laws. Next, we have the state lists. This includes all matters important to the functioning of a particular state, like transport, trade, commerce, agriculture, etc. The state government is the deciding authority for framing laws on these subjects. And finally, we have the concurrent list. This list includes topics on which both the union and the state government can make laws. These are related to education, forests, trade unions, etc. One point to be noted is if the two governments are in conflict with these laws, the decision of the union government will prevail. It is the final authority. Legal sovereignty of the Indian nation is vested in the people of India. Political sovereignty is distributed between the union and the states, with greater weight in favor of the union. Another reason which militates against the theory of the supremacy of states is that there is no dual citizenship in India. Thus, the learned judges concluded that the structure of the Indian Union as provided by the Constitution is centralized, with the states occupying a secondary position vis-a-vis the center. Hence, the center possessed the requisite powers to acquire properties belonging to states. As against this opinion was the judgment rendered by Justice Subba Rao, the great champion of state rights. Justice Subba Rao was of the opinion that under the scheme of the Indian Constitution, sovereign powers are distributed between the Union and the states within their respective spheres. As the legislative field of the Union is much wider than that of the state legislative assemblies. The laws passed by Parliament prevail over the state laws in case of any conflict. In a few cases of legislation where interstate disputes are involved, the sanction of the President is made mandatory for the validity of those laws. Further, every state had its judiciary, with the state high court at the apex. This, in the opinion of the learned judge, does not affect the federal principle. He gives the parallel of Australia, where appeals against certain decisions of the High Courts of the Commonwealth of Australia lie with the Privy Council. The Indian Federation cannot be negated on this account. In financial matters, the Union has more resources at its disposal as compared to the states. Thus, the Union, being in charge of the purse strings, can always persuade the states to abide by its advice. The powers vested in the Union in case of national emergencies, internal disturbance, or external aggression, financial crisis, and failure of the constitutional machinery of the state are all extraordinary powers in the nature of safety walls to protect the country's future. The power granted to the Union to alter the boundaries of the states is also an extraordinary power to meet future contingencies. In the respective spheres, both executive and legislative, the states are supreme. Now, the minority view expressed by Justice Subbarao has consistency with the federal scheme under the Indian Constitution. The Indian Constitution accepts the federal concept and distributes the sovereign powers between the coordinate constitutional entities, namely the Union and the states. The crux of the majority judgment in this case is that even though both the Union and the states in India derive powers from the same constitution, the states would have no legal rights as against the overriding powers of the Union because of a general theory of paramountcy or superiority of the Union. The extent of federalism of the Indian Union is largely watered down by the needs of progress, development, and national integration. The judiciary had interpreted the constitution to declare India a unitary nation. This view of the apex court has lately undergone a change. The court has now recognized the fact that the framers of the constitution intended to provide a federal structure with a strong center which would prevent disintegration of the nation. However, there are certain provisions of the constitution which clash with its federal nature. Firstly, the Union has the power to make new states or alter the boundaries of existing states. Secondly, Union has the power to make laws on state matters, and if both state and Union adjudicate on a certain matter, the latter will prevail. And thirdly, the emergency articles of the Constitution, when conjured up, give a unitary character. The motto of unity in diversity has always been very important to India, and a federal government helps to establish a country with mutual tolerance and existence. However, for a country like India, which is divided on linguistic and communal basis, a pure federal structure would lead to disruption and division of states. With too much power given to a state, it will want to shift away from the union and establish its own government. We need to strike a balance between both unitary and federal features of the country. States should be autonomous in their own sphere, but they can't be wholly independent. The Constitution establishes a state which is both a union and a federation at the same time, and thus gives India a structure of a quasi federal government which has united the diversity of India. Now, these are the lines you can use to conclude your answer to your question on federalism. Talking about present times, the whole world has been severely affected by the COVID-19 pandemic. India's response to the COVID-19 pandemic has shifted the balance of its federal structure. The pandemic has enabled the central government to implement far reaching reforms in areas such as agriculture, traditionally considered to be the domain of states. This exercise by the central government is indicative of its willingness to take advantage of a global crisis and use the levers of federal power to implement significant reforms. It also indicates that, contrary to conventional wisdom, the constitutional structure of India's federalism is less relevant to the actual relationship between India's national and state governments. The initial stages of the COVID-19 response highlighted the unitary tilt in the Indian federal structure. The central government implemented a national lockdown using its powers under a central disaster management law, and its Ministry of Home Affairs issued extensive guidelines to states for controlling the pandemic. This law empowers the central government to commandeer state and local authorities if necessary. State governments agreed even though they have independent powers under a more specific law, that is the Epidemic Diseases Act of 1897. Subsequent phases of the lockdown have seen their autonomy restored, but Indian states now have less functional power relative to the center. Since the national lockdown required shutting down almost all economic activity, there was a drastic reduction in revenue for state governments. This erosion of political and financial capital has enabled the center to benefit at the expense of states. In May 2020, India's finance minister announced a series of reforms to facilitate India's post-lockdown economic recovery. Many of these measures impinge on the autonomy of state governments and have only been accepted due to the unprecedented situation presented by the pandemic. One such measure has been a conditional increase in the borrowing limit for states. The central government enhanced the borrowing limit of state governments from 3% to 5% of their gross state domestic product. But only the first 0.5% of this increase is unconditional. A further 1% will be permitted only if the borrowing is linked to specific reforms. Reforms in the agricultural sector impinge even more on state authority. Agriculture is a state matter in India, and states tend to oppose even modest reforms suggested by the central government. The recent reforms completely dismantle the long-standing agricultural marketing system, which monopolized trade in agriculture within states and prevented the growth of a more efficient agricultural marketing system. Both measures, the increase in borrowing limits and the agricultural reforms, are examples of the center using the pandemic as an opportunity to address long-standing governance issues in many Indian states. In doing so, it has recognized that the pandemic has created unique financial and political vulnerabilities in state governments. The adoption of federalism has been a source of some tension between the union and the states. Implicit in the debates surrounding federalism, both at the founding and now, is the theory that a certain function will be performed better at a certain level of government. Powers are allocated and reallocated, keeping this principle in mind. So, for instance, the limited attention devoted to primary education during the Nehruvian era, when education vested exclusively within the domain of the states, inspired the view that the subject would gain importance only if the center had involvement, leading to a constitutional amendment taking it away from the states' exclusive control. On a wide array of matters, ranging from the delivery of services to natural resources, the Constitution's allocation of powers between the Union and states has had deep implications. Take a less talked about example: the exclusive power of the states on the police, a vesting which flows from the belief that crime relates to contingencies and circumstances which are local and necessitate micromanagement. True as this may be, the power of the states over the police has probably been the single largest reason why the center has found it impossible to initiate police reforms. The challenge of federalism is to be able to identify the appropriate level of government for the exercise of a certain function. The way in which we allocate powers ultimately reflects a certain vision of the state and the economy, and the institutional idea that while one thing may be better done centrally, another requires regional authority. We thus find in the Constitution an image about how the state and the economy work. The political tension emerges from the fact that occasions sometime arise in which constitutional allocation are dysfunctional. And little can be done because of the long process of changing the particular article of the Constitution. This is because the consent of the states is also required for such changes, since it impacts their powers. On the other hand, this difficulty in changing constitutional allocation helps preserve the autonomy of states and prevents the center from engaging in self-aggrandizement. Well, that's all from me in this video. This video is based on the information freely available on the internet. No originality is claimed for the same. The intention of this video is only to prepare candidates for answering examination questions on the subject and not for any financial gains. Do like and share this video and do subscribe to my channel now so that you do not miss out on my previous or future videos. Till later then, cheerio.